The floor is yours, sir.
Perfect. Thank you very much. Well, I'd like to begin by acknowledging that the land on which we gather is the traditional unceded territory of the Algonquin and Anishinaabe people. Thank you, Chair and members of the committee, for inviting me here today. I appreciate the opportunity to appear before this committee to shed light on my findings in my office's recent report on procurement practices of federal departments pertaining to contracts associated with ArriveCAN. My name is Alex Yeglich. I've been the procurement ombud for just under 6 years. Je remercie le greffier et le comité.
I'd like to thank the Clerk and the Standing Committee on Government Operations and Estimates for inviting me to appear as a witness in the ArriveCAN case.
The team lead for the ArriveCAN report and Acting Director of Inquiries, Quality Assurance and Risk Management. Le Bureau est indépendant.
The office is independent from other federal organisations, including Public Services and Procurement Canada. Specifically, our legislative mandate is to 1. Review complaints from Canadian suppliers about the awarding of a federal contract below $33,400 for goods and $133,800 in the case of services. Second, review complaints with regards to the administration of a contract regardless of their dollar value. And third,
federal departments to assess their fairness, openness and transparency and consistency with laws, policies and guidelines, which is why we're here today. So on November 14th, 2022, the House of Commons Standing Committee on Government Operations and Estimates adopted a motion recommending the conduct of a review by my office to assess whether contracts awarded by departments in relation to the ArriveCAN application were issued in a fair, open, and transparent manner, and whether contracts awarded on a non-competitive basis were issued in compliance with the Financial Administration Act, its regulation, and applicable policies and procedures. Once my office was able to establish reasonable grounds as per our regulatory requirements, the review was launched in January 2023. As per our legislated deadline, my office completed the review of ArriveCAN contracts on January 12, 2024. The report was published online on OPO's website, our office's website, on January 24th, 2024. My office completed a review of 41 competitive and non-competitive procurement processes and resulting contracts, contract amendments, and task authorizations, service orders under which was performed for the creation, implementation, and maintenance of ArriveCAN. The review does not include subcontracts, as these are beyond the legal authorities of the Ombud. CBSA, Canada Border Services Agency, was the client department for all 41 contracts. These contracts were established for CBSA by Public Services and Procurement Canada and by Shared Services Canada and by CBSA under its own contracting authority. Regarding competitive procurement practices leading to the award of contracts, all 23 solicitations reviewed were issued under a PSPC supply arrangement. Overall, solicitation documents were clear and contained information potential bidders required to prepare a responsive bid. For the most part, solicitations, solicitation amendments, and responses to questions from potential bidders were appropriately communicated, and bids were evaluated and contracts awarded in accordance with solicitation documents. However, mandatory criteria used in one solicitation leading to the award of a $25 million contract were overly restrictive and favored an existing CBSA supplier. My office also identified issues relating to the achievement of best value in many procurements. For 10 of the 23 competitive procurements reviewed, the use of overly restrictive median bands in the financial evaluation of bids stifled price competition and resulted in the rejection of some otherwise high-quality bids. In roughly 76% of applicable contracts, resources proposed in the winning bid did not perform any work on the contract. This is also known as
bait and switch.
Bait and switch. When TAs were issued under these contracts, the supplier offered up other resources, but not the individuals that had been proposed in order to win the contract. Files for non-competitive contracts included written justification for awarding the contract through a sole source process based on the exceptions to competition provided by the government contracts regulation. Insufficient records maintained by Shared Services Canada raised questions as to whether certain service orders under the GC Cloud Framework Agreement followed appropriate procurement practices. There was no documented procurement strategy for work associated with ArriveCAN, and multiple service orders issued to one supplier were treated as separate, unrelated requirements, despite the fact all were associated with ArriveCAN. A majority of the files reviewed were for professional services contracts through which work was authorized for ArriveCAN under a TA. Overall, documentation of TA's use for ArriveCAN was complete and for the most part properly authorized. However, 20 TAs of the 143 reviewed did not include the specific tasks, including descriptions of the activities to be performed. Resources authorized to work on a contract with TAs must be assessed by the business owner before a TA is issued to ensure the individual meets criteria for the resource category as specified in the contract. There were no assessments for more than 30 resources who were named on ArriveCAN related TAs. As the client department, CBSA was responsible for the proactive publication or public disclosure of contract information on the Open Government website for the contracts reviewed. Information was not proactively published for 17 of 41, so 41% of contracts reviewed. This result runs counter to broader government commitments to transparency and strengthened accountability within the public sector. As discussed throughout our report, we found practices for awarding competitive and non-competitive contracts, for issuing TAs and service orders, and for proactive publication of contract information that were inconsistent with government policy and that threatened fairness, openness, and transparency of government procurement. I made 13 recommendations to address the issues identified with procurement practices associated with the ArriveCAN application. Je vous remercie pour votre attention.
Thank you for your attention.
This committee for shining the light on these important procurement issues. It is from a commitment to fair, open, and transparent public purchasing that we must improve Canada's procurement system. Systemic reviews and audits are imperative to the proper functioning of the Government of Canada's purchasing powers and the work of committees such as OGO that play an important role in holding both the government and businesses accountable. Mon bureau reste disponible pour collaborer.
My office remains available to collaborate with committee members.
Thank you.